Motion of which year? Why it is not been? It has not been included.
Justice Roy, that is direction was passed to the matter to appear on December 17, but this matter is not good.
Month list of February.
Application for registration.
When dismissed for default?
Dismissed on 14th November 2025.
Month list of February.
Milord, may I be permitted to mention one matter, Milord? It is in the hearing list, Milord. Item number 415. Kindly remember, Milord, my lord has been pleased to vacate my interim order. Milord, I assert that order in appeal. Milord, although appeal court has not interfered with my lord's order, Milord, I prayed for early hearing. That option has been left open for me in view of an urgency. Kindly read, see, Milord, page paragraph 8. Page 3, Milord. In view of it, no direction has been given to my lord for early hearing.
But the Honorable Division Bench has said that there is no occasion for this court to issue any direction for.
Yes. There is no direction upon my lord. My lord,
Yeah.
it has been left open for me if there is an urgency. My lord, my mother is a patient of bipolar disorder, severe, my lord, a psychiatric patient. My lord, she is with me there in Guwahati. My lord asked me to join Guwahati, my lord. 1 week after this order, my lord, I have joined Guwahati. Today also I am in Guwahati, my lord. My mother went with me in Guwahati. Now, my lord, very recently, my lord, she has suffered syncope. My lord, I took her to Guwahati. Since my lord,
Happening in the list.
it is in the list, my kindly see, my lord, my mother has
Sorry.
been, my lord,
Yes, please. I have seen the order.
my lord, any date fixed, kindly.
But the field officer, sorry. Yes, I remember this matter.
My lord, kindly in that event, my lord, I am praying for release of this matter because, my lord, my mother is not.
Serve notice upon other side.
Definitely.
Yes. And then mention.
My lord.
Yes. Next Monday.
Honorable Division Bench directed the registry to place the matter the next week by an order of 19th December.
Yes.
Can you consider the order?
Yes, is what you are submitting?
The Honorable Division Bench remand the matter and directed the registry to place the matter before the regular bench in the next week. Order was passed on 19th December. But kindly consider the order. I have served notice upon the planning advocate for the state.
Which paragraph?
Page number 2, Milord, of the order. Paragraph 9, Milord.
This is my order which was under appeal.
With regard to maintainability of the writ petition, Milord.
it will appear in the list. Monthly list of February under the heading here.
There is some urgency, my lord. The authority is going to complete the selection process. We have challenged the selection process, my lord. Initially, they issued notification, recruitment notice. Subsequently, by issuing another notice, they have changed the entire selection process. My lord, written test has already been held, result has already been published. They are going to prepare the panel, my lord.
Till next Monday under the heading hearing.
My lord, for inclusion in the list, my lord, this is an old hearing matter, my lord. This was extensively heard by Her Ladyship, Honorable Justice Ananya Bandyopadhyay, but owing to the change in determination, my lord, this matter has gone out of the list. Well, this matter was mentioned last month, my lord. Your lordship was pleased to direct me to mention after some time, my lord. I'm just praying for inclusion in the list, my lord.
Wait for some time. Because hearing matter I am not including. This is a direction by the Honorable Division Bench, that's why I have included. Old matter, wait for some time. See the position in the list.
Inclusion for application.
Application for what?
For further order. সার্ভিস করতাম সার্ভিসে আমি অলরেডি জাস্টিস অরিন্দম মুখার্জি জাস্টিস উনি অর্ডার পাস করেছিলেন তো সেই অর্ডার পর আমি ক্যালকুটের কাছে নেসেসারি ডাইরেকশন পেয়েছি সেই অর্ডারটাকে আমি অ্যাপ্লিকেশন করছি রেখেছি যে আমাকে একটা ফার্দার অর্ডার দেওয়া মানে
মূল রিট পিটিশনটা পেন্ডিং আছে না সেটা পেন্ডিং আছে না ডিসপোজড হয়ে গেছে?
হ্যাঁ সে এটা অলরেডি পেন্ডিং আছে কিন্তু ট্রায়াল কোর্ট আমার অর্ডার পাস দিয়ে
হ্যাঁ কি অর্ডার পাস করেছে ট্রায়াল?
পাস করেছে যে সার্ভিস জয়েন করার বিষয়ে কনসিডার করেছেন আমার বিষয়
আচ্ছা, তো সেই কনসিডারেশনটা হয়েছিল?
সেটা কনসিডার সেটা আমি অথরিটিকে জানিয়েছি কিন্তু অথরিটি তার সত্ত্বেও কোনো ব্যবস্থা নেয়নি সেই হিসাবে আমি একটা অ্যাপ্লিকেশন করেছি কিন্তু আমাকে
কিন্তু মূল রিট পিটিশনটা তো ডিসপোজ হয়ে গেছে, তাহলে আবার অ্যাপ্লিকেশন কিসের? আপনার কথা শুনে যা মনে হচ্ছে মূল রিট পিটিশনটা কনসিডারেশনের জন্য ডিরেকশন হয়েছিল সেটা তো ডিসপোজড অফ, সুতরাং তারপরে তো আর অ্যাপ্লিকেশন মেনটেনেবল নয়। ঠিক আছে, গিভ দ্য স্লিপ মান্থলি লিস্ট অফ ফেব্রুয়ারি। ইয়েস,
May I give you lordship's kind leave for upgrade?
জাস্ট মিনিট। ইয়েস,
And insane one matter, this matter, though appears to be 2025, but this is third round of litigation. And the poor petitioner is suffering from the year 2018. My lord, in spite of,
হোয়াট ক্যান বি ডান? আই হ্যাভ ট্রাইং মাই লেভেল বেস্ট।
my lord, I am submitting, please hear me along with. My lord, in spite of having specific provision, they have not considered my humble prayer, returning me on medical ground. I am paralyzed. So from the year 2018, writ petition allowed. Which they have preferred appeal for the decision made, appeal dismissed. Contempt has been filed, but in contempt, they have passed an order against respect of that.
Wait, you have to wait for some. I cannot upgrade it. I cannot upgrade it at this stage. At this stage, I am trying my level best. Yes. Wait for some time. Yes. Sorry. Yes.
Other matters of the other petitioners of the same authority.
What is the urgency? Interest.
Interest and all that, they are.
Wait for some time, Mr. Bhattacharya. No. Interest matter, you have to wait. Please see the position. No.
Provident fund has also.
Yes, wait for some time. Interest matter, I know. Similar order will be passed, you have to wait. Your junior mentioned this matter, I remember. Yes. Yes, yes. Yes. Hand over the sleeve. Yes, Mr. Lahiri.
My lord, item number 290, petitioner before lordship is a medical officer, specialist medical officer. My lord, he had prayed that he should be given charges of a bed in charge. My lord, bed in charge are the persons under whom the patients are admitted. But my lord, he has not been given the charges and he is made to work in another my lord, places. This is PP unit where he is not supposed to work. He is a specialist medical officer. For not doing that, he has been issued show cause notices which are under challenge, saying that the superintendent of a hospital cannot issue any show cause notice to a medical officer who is higher in rank, group A, all. Whatever has to be issued from the director of health or the joint secretary. Well, these are the charges. These are the my lord, points. My lord, yesterday also another show cause notice has been issued. This is the third show cause notice. Thereafter, I am contemplating that disciplinary proceedings with.
Then let it be initiated. Let it be considered.
Well, I am praying that I should be given my lord,
no
work
upgradation.
bed in
Mr.
charge.
Lahiri, at this stage, no upgradation. If any, ultimately any decision taken, then mention.
I will suspend it at the meantime.
Lordship,
Yes. Inclusion for what? Motion or hearing? Of which year? Group 9, I don't have determination. Of which year? Motion of which year? 2024. What was the last direction passed? Please ascertain and then mention on next Monday. Yes.
Because can we would like to mention one?
Yes.
Not this pertains to overpayment of salary. Not in November, Lord, I have mentioned this matter directed to appear in December. December, I mentioned, Lord.
Overpayment of salary, then what is the urgency?
The urgency is, my lord, there is a notification which says if you serve the ex-cadre post, you are eligible to the higher grade. Despite that, we are alleging that there an overpayment has been made. Since the month of August, my lord, 35,000 is being deducted from my salary. I came up, this is the second round of litigation. Justice Roy directed the authority to consider the issue. They have rejected my. Well, kindly takes it up, 35,000 is being deducted. I'm only left with 20,000 to run my journey.
Well, let me see. At this stage, I am not upgrading. Let me see. Yes.
Let that be included in the list.
It is not appearing in the list. Oh, month list of February. Let it appear in the list. Very well. Sub notice of honors. Yes, yes.
May I be permitted to mention one matter for inclusion? The petitioner is the serviceman of the CRPF. He was awarded compulsory retirement back in 5th December 2020. But the urgency is that he is approaching his retirement age, and by 2027 he will be retired. And this writ petition will become infectious. And he
Retiring on?
2020.
It is appearing in the list.
No, it is not appearing in the list.
When you have filed it?
I have filed this on 20th June 2023.
20th June 2023.
Yes,
It is not appearing.
It is
It is motion.
under any head.
It is motion or hearing.
It is on motion.
What was the last order passed?
That I have to take.
Ascertain and then mention next Monday. Yes.
My lord, I am mentioning a matter. Petitioner is Group D level 1 staff in Railway Department, my lord.
What you are praying for?
My lord, I am the matter is 298 of monthly list, my lord. I am praying for upgradation.
What is the urgency?
My lord, he is the only earning member in his family, and he is denied with his salary for more than 9 months, my lord. If the matter is not heard, my lord.
2023 matter you have to wait. Yes, sorry.
Lordship, contempt application for inclusion.
Hand over the slip.
Lordship, may I be permitted to mention one motion for inclusion?
Of which year?
Which year, Lordship, the petition was filed in the
Writ petition of which year? Please tell me.
writ petition of Lordship 2012.
12.
Lordship, kindly hear me kindly. On 24th October 2025, an order was passed because this petition was previously before another advocate. Thereafter, the petitioner getting no result, he went to Calcutta High Court Legal Services Authority. Thereafter, we were appointed, and then the matter was, we filed the condonation application. The 11 days was delay. So Lordship directed that.
Delay for what? Dismiss for default.
Yes, Lordship. The matter was dismissed on 30th October 2022. Thereafter, the petitioner came through Calcutta.
So from 12 to 22, it was under the heading motion.
Yes, Lordship.
We will believe it.
Lordship, I have that chart.
Yes.
I have annexed the order of 24th October 2025, Lordship.
What we?
Yes, Lordship. Thereafter, the Honorable Justice Anirudhurai directed that you pay for 11 days condonation. He directed that you pay 2,000 rupees to the Bar Association, High Court, Calcutta, benevolent fund. Thereafter, the petitioner has complied that, and so, Lordship, I am mentioning the matter as motion for inclusion.
Motion.
Yes, Lordship. The matter is
Very well. Let my officer check up the file.
Yes, I shall give the.
Then
chart,
he will intimate you. If necessary, he will mention it again on next.
My
one.
lord, may I be
Yes.
permitted to mention one matter? My lord, the areas of salary due since 2021, and
Let it be
he's an
included in the list.
yes, he's an
Writ petition of which year?
2025.
Motion.
Yes, my
Hand
lord.
over the slip.
May I permit?
Yes. Yes, yes, yes.
Sir, your lordship, I had mentioned on 15th and 22nd, yet my name has not come in the monthly.
What you are praying for, tell me.
I'm praying for my.
Mere mentioning will not do. What you are
There are
praying for?
several items, mainly promotions are there, and IS.
What is the stage of the writ petition?
The state, I gave you the order.
What is the stage of the writ
I
petition?
had given the orders by Anuruddha Roy.
What is the present stage of the writ? It is at the motion stage or hearing stage?
Motion.
What was the last order passed?
Last order that the date was 11/11/25.
Yes.
11/11/25.
Prior to that, what was the order passed?
The order was that
Writ petition of which year?
25.
2025. And on the first date, what was the order passed?
The first date order was that the next date will be, because due to some inconvenience, the next date is 11/11.
Yes. Still the matter is not appearing in the list.
No.
দেখবে তো ফাইলটা যদি না থাকে monthly list of February under the heading motion করবে। Yes.
Matter for inclusion under an application matter. Last month I mentioned the matter was pleased to direct to appear the matter in the monthly of January. Matter is not
File has not come probably. The writ file has not come.
Intimated me the file has been in this court, my lord. File has been come to
দেখো writ file থাকলে পরের মাসে
my lord, any day
not a single matter is lying before me which are not listed. Try to bring the file. I am also there is a standing order that bring all files so that matters can be accounted. Yes.
directed to matter be appeared so that but it was not listed. Old content.
Probably writ file has not come. What you are saying? If it is not there, monthly list of February, yes. দেখো ফাইলটা আনাতে পারো তুমি। Recalling when dismissed for default. And when you have filed the recalling application. Section 5. Have you filed it? Section 5 you have filed it. And the recalling. There are two applications. Hand over the slip. Yes. It will appear if file are brought in, then it will appear. All matters are being included. Hand over the how many matters? What is the matter about? What is the matter about? What was the order passed by the vacation bench? Then what is the urgency? All the three petitioners are dismissed. So why three petitioners? Why three writ petitions? 2025 writ petition. দিয়ে দেবে combined list of February. Yes.
Your lordship would recall that with respect to the PhD candidate, where the Supreme Court a circular has been held to be applicable for all the persons who are casually employed in the.
So you are mentioning in respect of motion or hearing?
It was in motion. My lord directed the matter to appear in hearing on 4th of November. So it is appearing.
Hearing matter I am not including at this stage. Sorry. You have seen what can be done. Also you have to appreciate my difficulty.
It's an open and shut case.
Yes. Hearing matter when I will include all. Because it is already appearing in the list. Very well. Let it be there.
If some precedence can be given.
No, at this stage. Not at this stage. Let it be remain.
Something can be done, but kindly, Lord. In this Lord, there is nothing to be decided. It has been decided at Supreme Court.
Very well. Remind me after 15 days.
If I need to mention a matter, my lord, for inclusion. It is a writ petition. It is come before vacation bench. There is the order.
Monthly list of February, yes.
My lord, extension of interim order.
When
Point
expired?
In the January of 2025, my lord. Application has been filed, my lord.
When it was expired? Today we are in the January
2025, my lord.
Application it will appear.
My lord, much
I'm
obliged.
mentioning an application for clubbing of 3 writ petitions. I mentioned this matter on 15th of December, but Lordship had directed the matter to appear on the monthly list of January, which is not appearing. Lordship, there is the one urgency. I've been informed that the disciplinary proceedings has finished, but there's a subsisting interim order that the disciplinary proceedings end result can only be published subject to the leave of this honorable court. Lordship, the bank has not taken any steps for obtaining.
What you are praying for?
I'm praying for inclusion of the application
of clubbing of the three writ petitions.
Very well, let it appear under the heading application in the monthly list of February.
Lordship, may I be permitted to mention a matter, Lordship? I had earlier mentioned this matter, Lordship, in December. Lordship directed it to appear in
Motion or hearing?
motion, Lordship.
Of which year?
2025, Lordship.
Hand over the slip, it will appear.
It may be upgraded, Lordship. There is an urgency, Lordship. The petition.
All matters cannot be updated in this fashion. Sorry.
Well,
Then this court cannot make any progress in the list. Yes. Yes.
Permitted to mention one 2020 writ petition, Your Lordship, for inclusion in the list, Your Lordship. The
2023 petition.
2020, Your Lordship.
The hearing matter.
Hearing matter.
Hearing matter. Wait. Sorry.
The monthly list.
No. No, not at this stage. I have disallowed others. Yes.
One matter is in motion stage since 2024, Your Lordship, 25, So I had filed an application for intervention. I had mentioned
Application for
intervention.
intervention. Let the application be included in the list under the heading
Yes,
application.
it is already in the list, Your Lordship.
It will be taken up.
Since May 2025.
All applications I have exhausted from the combined list. What you are saying?
It was under the assigned matter since it is.
Oh, say
Yes,
the
Your
assigned
Lordship.
matter. Tell
It
me.
may be hard, Your Lordship.
Yes.
They're unemployed youth and they are very disappointed.
See that the people are not getting pension, or otherwise unemployed youth. What can be done?
Got some salary. These people are not getting any.
No, there are a lot of matters where the people are not getting salary also.
Yes, Your Lord, but kindly consider. Your
Yes, it is already appearing in the list. Let me see.
Any day may be
Yes.
fixed, Your Lordship. I had mentioned many a times.
Yes.
Partnership, my lord, upper primary recruitment process of 10% reservation reserved for para teachers, my lord.
You have to wait for some time. Today I cannot fix up a date. I remember this one. Mention after some time. Yes.
No, she really helps.
Yes, Mr.
Lord, is a repetition, Lord, for hearing 2015 repetition. Your Lordship kindly include.
2015. Motion, it is a hearing stage.
Hearing.
You have to wait. I am not including any hearing matter at this stage.
But Lord, very old matter.
What can be done? When I will include hearing matter, send your junior, I will include it.
My Lord.
Yes.
This matter appearing in the monthly motion 1, item number 329.
Very well, let it run in the list. It is not under the heading motion. Yes. What was the order passed by this court? That's why. Sorry. No, you have missed the bus. See the position, how many mentioning are being made for inclusion. Sorry. Yes.
Answer this item number 256, madam.
Yes.
Madam, the respondent also has accepted the assignment of the petition.
When rejected?
On
Yes.
2024, my lord. My lord, the petitioner is.
See, all matters are urgent. That's why matters are being moved under the heading motion and under Article 226. But all matters cannot be accommodated in the list. You have to wait. What can be done? And regular filing is there. Wait, sorry, no upgradation. Yes.
Listed for motion already. Only 120 days leave salary out of 300.
Motion is not appearing in the list.
No.
Writ petition of which year?
25.
What was the last order passed?
Last order, not a year.
Never. Hand over the slip, monthly list of February.
My lord,
yes.
May I be permitted to mention this 2025 writ petition, my lord, which came up before your lordship on 24th of September 2025, my lord. Since the state was not appearing, my lord, your lordship directed this matter by a judicial order to appear in the monthly list of December 2025. The matter did not come up, my lord. I mentioned it in the month of December on 15th, my lord, before your lordship, my lord. Your lordship orally directed this matter to come up in the monthly list of January 2026, my lord, but it's not there.
Record is not there. You also make an attempt. I am also directing my officer to try to bring the record. If records are available, all matters are being.
So
May I permitted to mention one motion matter of year 2025. Had mentioned this matter, your lordships had directed for appearing this matter in the monthly list of January, but still, my lord, it is not appearing. Now, may I just hand over the
Monthly list of January,
Yes, my lord.
not appearing. So perhaps file is not there.
My lord, I am just handing over the slip, my lord. I shall also direct my clerk and he shall.
Yes,
If
yes.
it appears, my lord, if it
দেখো তো এগুলো আনাতে পারো কিনা, যেগুলো আমি ডিরেকশন দিয়েছি লিস্টে আসবে না কেন, সেরকম হলে ম্যাডাম ইয়েকে ডেকে পাঠাও। এটা
My lord, and this is one contempt matter, matter, due contempt matter. This one also I had mentioned. This was also directed to appear in the monthly list of January.
file is not there. Contempt read file has to be attached.
Perhaps
That's why file is not there.
I shall make an endeavor.
Yes, yes. Hand over. Yes. Any other mentioning?
Not grateful, my lord. Obliged.
Yes, 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 yes.
My lord, may I seek leave to file and move this writ petition?
Before me, no leave is required. If you file it, indicate the date. On that date, it will come up.
My lord,
Perhaps you were not aware of this procedure.
My lord, the urgency is, my lord, kindly, my lord, allows me. My lord, and recruitment was announced by the West Bengal Health Recruitment Board, my lord. My lord, thereafter, my lord, in the pharmacist grade 3. Now the applicants are, the petitioners are all the eligible applicants to this recruitment process. Now, my lord, we have all the requisite qualification. However, my lord, our candidature was rejected, citing the reason that our renewal certificate was not uploaded within time, my lord. That is, and my lord,
Renewal, what renewal certificate? OBC?
No, my lord. My lord,
EWC. Then?
My lord, since, my lord, we are pharmacists registered with the Indian Pharmacy Council, West Bengal Pharmacy Council, under the Indian Pharmacy Act, we have to be registered. My lord, that certification has to be renewed.
So if you file a writ petition indicating a date, on that date it will come. Why you are mentioning? I fail to understand.
The urgency is,
Yes, yes, Mr. Karim.
This matter relates to the withholding of the hardship allowance to the BSF personnels. Well, we have filed. The court was directed to file a comprehensive report. My lord, it reveals from the report that the matter was pending before the authority for
Writ petition of which year?
22, my lord. The
Hearing matter, you have to wait for
no hearing, no hearing, no affidavit direction was there. Nothing. Only, my lord, short for a report. Thereafter, the matter was lying pending. We were waiting for the report. Report was come up with a plea that the matter was pending before the department. So we are seeking a direction for disposal of the writ petition. Your lordship, kindly include
report is there. On the basis of report, you are seeking, you will pray for disposal.
Application because the matter was pending before the ministry for, my lord, taking a decision. So, my lord, let the matter have expired. Otherwise, the matter was pending since in the meantime, my lord, 107 battalion maybe move from here to elsewhere. So we are not getting the benefit. So you'll try your luck. If possible, my lord, not. If not, my lord, I don't know what would be the fate.
Then a file has to be brought in.
I put my 100% to be cautious. Kindly include that.
Very well. এটাকে next Monday to be mentioned দেবে যদি ফাইল আনাতে পারো।
ঠিক।
Tuesday.
So kind of lordship. So kind of.
My lord, may I get permitted for the upgradation?
Yes.
The petitioner seeks increment for his pay scale based on the post.
Increment, sorry, you have to wait. No upgradation. Yes.
Lordship, may I be permitted to mention a matter for inclusion?
Yes.
Inclusion.
Hearing matter.
No, no.
Motion of which year?
2025.
2025. It was never heard.
No.
Hand over the slip.
My lord, may I be permitted to mention, my lord, upgradation, my lord, item number 290 of your lordship's today's list, my lord. During the pendency of the writ petition, my lord, several show cause has been issued against the petitioner, my lord.
When you have filed the writ petition?
2025, my lord, very.
Yes, on similar ground, I have disallowed prayer of Mr. Onindo Lahiri. The several show cause notice, I have not allowed upgradation. Yes.
Your lordship, mentioning for inclusion for the year 2023.
Inclusion, hearing or motion?
Motion.
What was the last order passed?
Last, yes, your lordship.
What was the last order passed?
Last order, actually, I am.
Ascertain and then mention on next Monday. Call the list.
My lord, will I give it a chance this month in the daily list also?
Yes, I have already directed. Sorry.
Pardon?
It will appear. Yes, please call the list.
Item number 1.
In this matter, my lord, I am.
Talk to my officer. Yes.
I am for the, here is the affidavit of service, my lord. This is the case, my lord.
Lord, I am appearing for the respondent number 4 and 5, my lord. But before my learned friend opens the matter, my lord, I need some time to take the factual instructions on this matter. However, I have gone through the petition, my lord. There is a issue of limitation. Let him test.
What you are praying for?
My lord, I am praying for
Lord, the grant of dearness allowance as declared by the state of West Bengal. Lord,
You are working where?
I am working in the government undertaking, West Bengal Saxby farmers, Westinghouse Saxby farmers, which is a Lord, government undertaking. Lord, in similar circumstances, this honorable court has passed an order. Lord, if your lordship kindly turns for a moment to that order, my lord, I take to them. Yes, sir.
What about court fees?
My lord, court fees, I have paid individual cases to all the petitioners, paid the court fees, my lord. Lord, that part I have taken, my lord. Lord,
Yes.
the order, my lord, passed by this honorable court.
Order will come later. What is the matter? Please
The matter
demonstrate.
is, my lord, Westinghouse Saxby Farmer is a government undertaking, and since, my lord, is inception of the company, whenever government directs to grant dearness allowance, they paid accordingly. The Westinghouse Saxby. For the first time in January 2017, my lord, government passed order directing all government undertakings to pay the enhanced dearness allowance. That is Annex P3 to the writ petition. My lord, thereafter, my lord,
Page,
my lord, I am telling you, lord, page, my lord. Page, my lord, 42. Page 42.
2017 memo.
Yes. Thereafter, my lord, next page, my lord. 18.
We are representing Westinghouse Saxby
Yes,
Pharma
ma'am.
Limited.
Yes, my lord.
Now, why the DNS allowance at the rate which is applicable so far government employees
Lord,
are
if your
concerned is
lordship
not being
sees
paid?
the case today, my lord, the petitioners are coming, my lord. If your lordship sees paragraph 8 and 9, the effect of the increased dearness allowance was supposed to be given from 1st January 2017. However, it was made clear in the...
Just a minute.
Yes.
So you are seeking DNS allowance from 1st of January 2017
For 7 months?
From 30th of October 2017. And 31st of October 2017.
Thereafter, my lord, 2018, that has also not.
So why you are coming in 2025?
Lord, because of this, it is the.
Because this is the area of dearness allowance you are seeking.
Yes, I am only.
Because from 1st of November 2017, you are getting. Please allow this court. From 1st of November 2017, you are getting dearness allowance. You are seeking area from 1st of November 2017 to 31st of October 2017. So why you have filed the writ petition after 8 years?
My lord, first of all, to the question put on me, my lord, the first of all, this is a continuous cause of action. First,
yes.
First of all. Second thing is, if this amount has been paid,
if it is continuous cause of action, then you are entitled to get from the date of filing of the writ petition. That you are getting.
No, I am not getting. I have retired.
You received dearness allowance from 1st of November.
No, that is my whole case. Not only 8 months has not been given. 3 months they have.
You received dearness. You did not receive dearness allowance at the appropriate rate from 1st of November 2017.
No, that has not been given. Only 8 months, 3 months they have given. 3 months they have given.
No, that is not the case made out. Paragraph 8 and 9 says that some of the employees were given DNS allowance from 1st of January 2017, but that was for a period of 3 months.
That is for a period of 3
But
months.
you received DNS allowance from 1st of November 2017. That is the case.
For 3 months I have getting. My whole case is I am entitled from 1st of November, 1st of January 2017.
From 1st of January 2017 to 1st of November 2017, there was no payment, non-payment of DNS allowance.
True.
Then petitioners received DNS allowance from 1st of November 2017 onwards till their respective dates of retirement. Now, some of the employees approached the authority. There for 3 months, DNS allowance was paid.
Only 3 months, and the rest amount.
So why you are coming after 8 years?
Because, my lord, thereafter again government passed an order 2018. Next page, my lord. That also not been given. And, my lord, 2019 that has not.
Let a joint representation be made.
So paragraph 11 and 12.
To the authorities.
Milord, the thing is that, Milord, if
The
your lords-
authorities, let it be decided that why is DNS allowance from 1st of November, 1st of January 2017 to 31st of October 2017 was not paid.
Milord, the reason is, Milord, as I understand, Milord, the state government in the order itself made it clear that no separate fund would be given. It's a loss-making company for a long time.
Decide this issue. Because
Milord,
some of them were
there is a
paid for 3 months.
Absolutely barred by limitation.
No, it's a continuing cause of action.
Milord, because
if I am entitled to get a particular benefit 20 years back and I retired thereafter, but it was not paid to me, definitely I can come.
Milord, they are asking for the increased dearness allowance for a particular period. That is 7 months in the year of 2017 and 2 months in the year of 2019. It's not a case that they have not been paid. Thereafter, they are
Not
paid.
a case of, are you aware of Tarsem Singh's judgment?
No, Milord.
Supreme Court judgment. In the case of retirement dues, it has been said delay is no ground.
So that is similar.
And it's not a case of
not a retirement.
and it's not a case of creation of third-party interest.
No, it's not a case of that is true, Milord. Whether the delay is material or not.
Then who is to decide it?
My lord, the managing director has to say, my lord, in the light of judgment I have, and in the light of that judgment, my lord, is also kindly consider that. Well, order.
Have you made managing director party?
Yes,
Yes,
I've made-
number 5.
Issue. All are retired employees.
All are retired.
Affidavit of service filed on behalf of the petitioner is taken on behalf of the petitioners is taken on record. Next paragraph. Petitioners were employees of Westinghouse Saxby Farmer Limited. Stop. Petitioners retired on superannuation. Stop. Common grievance of the petitioners is non-payment of DNS allowance for the period from 1st of January 2017 to 1st of November 2017 or 31st of October 2017.
But out of that 10,
it is also submitted that some of the petitioners received DNS allowance for a period of 3 months. 3 months during this period from 1st of January 2017 to 31st of October 2017, but for rest of the period, DNS allowance was not paid. Stop. However, it is contended on behalf of the petitioners that DNS allowance was paid to the petitioners regularly on from 1st of November 2017.
But DA on increased rate, Milord. DA
31st
was
of
paid.
October 2017. Stop. Next paragraph. Respondents are next paragraph. Westinghouse Saxby Farmer Limited, being the contesting respondent, is represented by learned advocates who has opposed this petition on the ground of delay in approaching this court by the petitioners seeking direction for payment of house rent allowance for the period from 1st of January 2017 to 31st October 2017. Stop. In addition, there it is submitted that some of the employees were paid DNS allowance for few months. Next paragraph. Having considered the submissions made on behalf of the parties, it appears that having considered the submissions made on behalf of the parties, court finds an allegation has been made on behalf of the respondents that they are not paid dearness allowance from 1st of January 2017 to 31st of October 2017 till date of 31st of October 2017. Stop. Though it is urged on behalf of the respondents that there was delay on the part of the petitioners in approaching this court, but court does not find substance in such submission, as it is not a case of creation of third-party interest, and if petitioners are found eligible to get dearness allowance, necessary steps are required to be taken by the concerned respondent authorities for release of such benefits. Next paragraph. In view of aforesaid scenario, leave is granted to the petitioners to make a joint representation to the chairman, to the managing director, Westinghouse Saxby Pharma Limited, being respondent number 5, seeking release of dearness allowance for the period from 1st of January 2017 to 31st October 2017 by fortnight from the date of communication, by fortnight from date. Stop. If If such representation is made on behalf of the petitioners, respondent number 5 is directed to decide the same in accordance with law by passing necessary order by 8 weeks thereafter. Stop. Respondent number 5 shall pass a reasoned decision after granting opportunity of hearing to one of the representatives of the petitioners, to one representative of the petitioners. Stop. Petitioner shall also be at liberty on behalf of petitioner shall also be at liberty to rely upon relevant documents as well as orders passed by this court previously in order to substantiate their claim. Stop. The decision to be taken by the respondent number 5 shall be communicated to the petitioner by fortnight thereafter. Stop. Read petition as disposed of urgent Xerox certificate copy.
Objection to your lordship. As I understand, my lord, because it is a loss-making company and they don't have the fund.
Take decision.
Order. May I take that order?
Yes.
Agree. Item number 2.
I am for respondent. Sorry. No.
I am for the petitioner.
Yes.
This is my affidavit of service. I have already served. The husband of the petitioner was working as a constable. He was posted in Alambajar in Kolkata. In 2019, Milord, he died in harness. Now, the petitioner wife, Milord, she made an application for appointment on compassionate ground. The application, Milord, was wholly rejected on the ground of age bar because he was, as according to them, she was more than 40 years old. The impugned order, Milord, that is at page 31, that I have challenged, and they have alternatively made another decision to give me an employment under SRA PSF Contributory Welfare Fund. So that has also not been done, Milord.
BSF.
BSF.
Yes, why petitioner is not offered a vacancy under SRF BSF Contributory Welfare Fund?
Yes, my lord, his prayer is that he is asking for compassionate appointment.
Yes.
Page 9.
But at the time of taking decision, page 31, 19 November 2024,
Yes.
it is stated that she was found overaged. So that's why in BSF appointment cannot be made. But now Srimati, now the petitioner
Asking for
uh,
welfare fund. So, my lord, give me sir.
has forwarded a letter addressed to Commandant 27 Battalion BSF regarding service in BSF through SRF BSF Contributory Welfare Fund.
Yes.
Now, paragraph 3 says, in view of above, request intimate if such type of vacancy is available under SRF BSF. This was issued by the commandant addressed to the sector headquarters.
My lord, she is asking in a money value from the contributory welfare fund. And
But then why paragraph 3 vacancy is stated?
yes, that is the thing. Lord,
In view of for Commandant 27 Battalion BSF,
so question of
saying
welfare
addressed to the sector headquarters, Border Security Force, Gurudaspur.
On the one hand fund and on the other hand vacancy, that does not match. So, my lord,
Obtain instruction, come back.
And another thing, my lord, may I submit?
Issue. Affidavit of service filed
My
on behalf
age
of the
was not
petitioner is taken on
40.
record. Stop. Petitioner prays for appointment on compassionate ground due to death of her husband. Your husband died?
Yes, husband.
But you have challenged 2nd September 2024 memo.
yes.
Where is that?
19 November 2024.
Where is that? 2nd September 2024?
That is.
Take me to that
page
Indian
tw-
memo.
That is page 29. That has been, my lord, communicated through this memo. Page 29.
Just a minute.
So that's why he has asked for compassionate appointment.
But if you are overaged, then how appointment can be given?
Yes, that is not my point. That when my application for compassionate appointment, that is at, my lord, page 16, the date is 4th May 2023. Now in page 18, my lord, kindly see, they have accepted my application 4th May 2023 and my date of birth is 12 May 1982. So at the time of making application, I was within 40, not above 40. And my second point is, my lord, compassionate appointment.
When you made the application?
Page 17, last, my lord, date is.
Please
there.
tell me the date of
4th
making
May
application.
4th May 2023. And page
But
8,
in the affidavit, you have stated 43 years.
yes, in affidavit page, that is 43 years. It is
So
aged.
therefore, on 2023, 2 years back, you are 41 years.
It is aged about 43 years. So more or less, you know, some months. If
what is your date of birth?
12 May 1982.
82.
82.
82.
12 May 1982.
So that is 43.
82. 12 May 1982. So on 4th of May, you completed 40 years on 12th May 12th May 2022.
12 May 2023. I completed 40 years. I was in 41 years in 12 May 2023.
No. How can it be? 12th May 1982 is the date of birth. Then 12th May 1992, you completed 10 years. 12th May 2002, you completed 20 years. 12th May 2012, you completed 30 years. 12th May 2022, you completed 40 years. So on the date of making application on 4th May 2023, you crossed 40 years.
Then, my lord, in that case, my submission is that, my lord, compulsory appointment cannot be denied only on the ground of age restriction, my lord.
How? If the policy does not permit, you have no right.
My
It's
lord,
not a vested right. Your
because-
right has to be considered based on the policy.
in recent, my lord, I have seen some. So, my lord, may kindly give me some accommodation. so that-
Recent judgment is Justice Datta's judgment sitting in the Supreme Court. Ajit Kumar GK versus Canada Bank. That will not come in your aid. Sorry.
My lord, my
We're
alternative.
taking note of all the previous judgments.
Then, my lord, my alternative prayer may be considered.
What alternative prayer?
A writ in the to provide compulsory appointment to the petitioner in BSF through SRA
When your husband died?
in 2019.
But at the time of date of death, the petitioner was within 40.
At the time, the petitioner was within.
So why you took so much time?
Yes.
19 died and 23 you made
That is, my
application.
lord, subject matter of my second writ petition, because there was a litigation between the mother-in-law and, my lord, the.
That is the problem. And 35 lakhs already paid.
Because the date of making application will be considered.
That may be considered. That's considered. So alternative prayer is there.
And
my lord.
35
may be
lakhs
considered.
already paid to him. That is the subject matter
So
of.
that is the terminal benefit. That petitioner is
Not
entitled.
terminal benefit, it is
But
because
don't mix up the issue with
No,
appointment
during
on compassionate ground.
No.
That is a separate thing.
No.
If under the scheme petitioner is entitled, you are required to consider the case of the petitioner.
during the service period.
Don't be swayed by payment of money, because that is
I'm not swayed.
terminal benefits which the petitioner is entitled to get in connection with the service of the petitioner, for service of the husband of the petitioner.
Well, possibly it is not the terminal benefit when your lordship will take it up. It is the benefit given to a soldier or BSF cadre because of untimely death and to aid the family.
But are you
Terminal
submitting
benefit is
that
different.
because of this payment, right of the petitioner to be considered
not
for
I am
appointment
not-
on compassionate ground is
I am not-
obliterated?
I am not claiming that.
Then
Lordship, whatever your lordship feels, my lord. Well, I have no instruction as such, but the question is, my lord, he has completed 40 years. That's why, my lord, he has been denied this employment. This what we could gather from this petition and from his application. So, my lord, second application he has asked for further.
No, now, yes, there is an order to that effect, which is at page 31, relating to appointment of the petitioner in SRF BSF Contributory Welfare Fund.
That is
Vacancy is available.
That is dual.
In view of above request, intimate, when you will take instruction, come back.
That is.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner has questioned memo dated or order dated 2nd September 2024 issued on behalf of Commandant 27 Battalion BSF Border Security Force, whereby prayer of the petitioner for appointment on compassionate ground due to untimely death of her husband was rejected. Stop. So it is submitted on behalf of the petitioner if she is found to be overaged. In that event, alternative arrangement can be made to accommodate the petitioner in terms of the subsequent communication dated 19 November 2024, which is at page 31 of the writ petition. Stop. Mr. Bajpayee, learned advocate representing Union of India, prayed for accommodation to obtain instructions. Stop. Hearing of this matter stands adjourned. This is the matter under the same heading for further consideration on 28th January 2025. 2026. Next.
Great. My lord, can I get some more time because it is.
I have given enough time.
My lord, it
Today we are on 5th. I have fixed it on 28th January.
it will be from
Not
Punjab.
7 days time.
Punjab it will be.
Please obtain instruction, come back.
All right.
Yes.
As you.
Item number 3.
My lord, I am for the petitioner. This is my affidavit of service.
Same applicant.
Same applicant, fact is same, my lord. Kindly see at page 21, during pendency of the writ petition between the mother-in-law and the petitioner before the Karnataka High Court, my amount that was 50 lakh was withheld for the reason of court order. Now, till day at page 26, I have made a detailed, my lord.
Then the mother-in-law of the petitioner has to be added as a party.
That is the
How I can give direction to make payment of 50 lakhs behind the back of mother-in-law who has initiated a proceedings in Karnataka.
Already mother-in-law obtained an order whereby the.
So that's why mother-in-law has to be made party.
Then may I, my lord.
Issue. Take back your affidavit of service. It is submitted on behalf of the petitioner that due to untimely death of her husband, who was serving in Border Security Force within bracket BSF, she is entitled to receive monetary benefits, which is not being released in view of pendency of litigation at the instance of her mother-in-law in Karnataka. Stop. Next paragraph. However, mother-in-law has not been added as party, has not been added as respondent. Next paragraph. Leave is granted to the land advocate representing the petitioner to amend the cause title of the writ petition and add mother-in-law of the petitioner as additional respondent in course of this day. Stop. After such amendment is carried out, land advocate for the petitioner is directed to serve amended copy of the writ petition and order passed today by this court upon the additional respondent by 3 weeks from date and file affidavit of service on the next date. Next paragraph. List the matter under the same heading for further consideration on 9th February 2026.
May I pray for one thing, Lord?
No. It has got no nexus with that matter. Previous
No,
matter.
not that matter, Lord. Let them file a report. What happened actually? Let the
Let
respondent
him serve. Let him serve and come back.
Item number 4.
Item number 4, my lord, my application is my affidavit of service.
Same petitioner.
No, different. The petitioner, my lord, while on service, he is working as constable. He has not yet been terminated from his service, but he suffered.
Where working?
In constable BSF.
BSF, yes.
He suffered injury in 2019 while he was on duty, my lord. But after some days, he started to face physical difficulties. Now, medical board is constituted and he is apprehending that he may be removed. So that one representation is at.
He may be removed.
Yes. Because of at page.
So in anticipation, what order court will pass? Let an order be passed affecting your right, then you can approach this court. It's a premature writ petition. You are apprehending that you will be removed from service.
Yes.
So how a writ petition is maintainable at this stage?
My only prayer is not they may.
Still you are working.
Yes.
So you are medically incapacitated.
That I apprehend that they may.
Received injury.
Yes. And
where you are posted, what you are praying for?
For representation of my
representation consideration, if it is meaningless consideration, then court will not pass any order.
At page 7, my lord, my prayer is there.
So that petitioners may not be removed.
Yes. If he removed, my lord.
Sure. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner is working as constable in Border Security Force within bracket BSF and apprehending that he may be removed from service, present writ petition is filed. Stop. However, from the submission made on behalf of the petitioner, it is found that till date no adverse order is passed against the petitioner. Next paragraph, Union of India is represented by learned. Next paragraph, having considered the submission made on behalf of the petitioner, it is found that the writ petition is premature and same is not maintainable at this stage. Stop. Hence, writ petition stands dismissed. Next paragraph. However, this order shall not preclude the petitioner to take steps in accordance with law if any order is passed against the petitioner in connection with his service. Urgent xerox certificate copy or parties to act on the server copy.
Item number 5.
I will appear for the writ petitioner.
I appear for the Union of India.
My affidavit of service.
Mr. Partho Ghosh.
Yes.
Led by Mr. Partho Ghosh, I am appearing for the respondent.
No, but your name will be recorded. Nobody's
Minor,
give your appearance only.
Minor.
Yes.
Well, the petitioner participated.
Where is Mr. Ghosh?
Today I received no intimation from him.
Yes. Yes, yes.
Well, he participated in the selection process of under the CAPF for the constable GD.
Yes.
My lord, the petitioner was qualified in written examination. Therefore, thereafter physical tests were conducted. He qualified himself to be at par with the status. Thereafter, the medical examination was held. My lord, the first detailed medical examination, petitioner was found unfit in on three grounds. Thereafter, review medical board was constituted. Review medical board found two of such ground.
Where is the review medical board?
First, may I take your lordships to the preliminary one?
Please come to review medical board order.
Review medical board order is at
Page
page
23. Annex chapter P4.
Lord, I was taking your lordships to the point of X-ray CA, left elbow 21.6.
What is today due to left?
Lord, left carrying angle. Lord, just the page before that, page 22, is the detailed medical examination report.
But left carrying angle is a valid ground.
Yes. Thereafter, what is my contention before your lordship is page 22 suggested 3 grounds. Page 23, those 2 grounds, that defective distance vision and left ear wax was obliterated, and this point was carried forward. But kindly takes the first page 22 left CA, that is below 10 degree. Now it changes to 21.6 in the review medical examination report. Then the petitioner got himself examined in the medical college, at first at Bidhannagar, Durgapur, not a medical college.
What is the angle in mentioned in review?
My lord, you must kindly seize page 23, that is
Left
report
carrying
21.6 CA.
Where from you are getting?
My lord, the signature, right hand side, 3 lines above that. Page 23, the signature of the concerned person.
Yes, 21.6.
It changes from below 10 degree to 21.6. Thereafter, the petitioner got himself checked at first at Durgapur, page 24, the government hospital, left hand corner, carrying angle.
Page 24.
Page 24, left hand corner, carrying angle, acceptable range of carrying angle. Thereafter, the degree was confirmed at page 25. It was checked before the Bardhaman Medical College and Hospital. My lord, will kindly seize the middle portion in the bottom, carrying angle normal 10 to 15 degree. Well, it is a report of the...
No, problem is this, in case of appointment and review medical examination and detailed medical examination, they are to follow their own guidelines.
Yes.
That may vary with the parameters for general physicians.
Yes, but in my humble submission, my lord, I may say this, my lord, that 10 degree and 15 degree is the parameter that they follow, which I have gathered from my clients. And initially it was below 10 degree. Thereafter, review medical board extended to 21.6. I have also have my lord, the radiological report annexed at page 27.
Page 24, what does it say?
Page 24, it says that it is within the acceptable range, left hand corner. It is from Durgapur Hospital. Thereafter, from the medical college and hospital, it transpires that
what is acceptable to the medical
I
college
understand what is
may not be acceptable to the medical expert
Yes.
who acted as medical expert
I
in-
understand from what is falling from
in
your
detailed
lordship.
medical examination and review medical
But
examination.
what
That's why they followed their own procedure.
What I
You demonstrate from 15th May 2025 guidelines that you ought to be declared as a fit candidate.
my lord, my lord, may I?
There is a medical
Yes,
guidelines,
yes.
detailed.
Yes, yes.
So show me.
My lord, as of now, I am
Revised medical guidelines, revised guidelines of May 2015 for detailed for medical examination.
Well, may I come back tomorrow?
Issue.
If you lordship.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner has questioned a report of review medical examination dated 2nd December 2025 in connection with the selection process for filling up the post of constable within bracket GD close bracket under Central Armed Police Forces. Stop. Next paragraph. During course of hearing, Mr. Chaudhary, learned advocate, representing the petitioner, has paid for accommodation. Stop. Union of India is represented by learned advocate. Stop. List the matter under the same heading for further consideration. On 14th January 2026.
Much obliged.
My lord, may a report be filed from my learned?
Sorry, first you have to make out your own case.
With
Don't make any submission in desperation.
no, yes. Not saying. But because they are having their guidelines with them, that is philosophy.
Next.
Item number 6.
I am appearing on behalf of the petitioner, my lord, affidavit of service as well as
I am appearing on behalf of Public Service Commission.
affidavit of service and my lord,
Court fee you have paid.
yes, both are there. Both are there.
Yes.
But this matter relating to my lord, junior assistant engineer appointment, my lord, by the PSC, my lord. Usually, my lord, the SAT is the determination, but due to my lord, there is no such.
You move the division bench.
Yes.
No, my lord.
It is
Defense of the-
amenable before the WPSC
defense of
determination.
with deepest of respect, my lord, the same thing, my lord, the coordinate bench, when one of the matter, my lord, I am arguing that, my lord, the first that ought to be the single bench. Why? My lord, I place my case, my lord, because of that, I want to cite it, my lord, 6 times. It ought to be in the single bench. Otherwise, my lord, I will lose a forum. Because usually in L. Chandra Kumar,
Question is L. Chandrakumar, paragraph 90 and 91.
93.
Paragraph 90 and 91, judicial review court. It's a judicial review power which can be exercised by the High Court, but not by the single bench, but by division bench.
Yes.
Now, question would have been different if there is no constitution of tribunal in a particular state. Then Rogers' judgment will come into play. But if there is a tribunal in a particular state, then a single bench of the High Court cannot be transformed into a tribunal.
Yes. About
It's not a question of Mr. It's not a question of losing forum. It's a question, it's a special circumstances,
Extraordinary, sir.
a special circumstances where tribunal is not functioning, perhaps due to no bench is available. Now then the remedy which is available to you is to approach the division bench.
My lord, in that case, my lord, I.
Because L. Chandra Kumar has to be read. আমার ওই বইটা আনো তো
handed over L. Chandra Kumar and as well as my lord,
ওই ইয়েটা আমার যে দেখবে বলবে যে আজকে ভোট যাচ্ছে আসছে আমাদের টেবিলের মধ্যে একটা ডিভিশন বেঞ্চের একটা এসসিসি আছে, তার মধ্যে একটা জাজমেন্ট ঢোকানো আছে, মানে তার মধ্যে একটা নোটও ঢোকানো আছে, ওই বইটা সমেত আনতে পারো।
Handed by L.
Yes.
And along with L. Chandrakumar Malar, I just want to cite Malar, 6 judge and very recent judgment, that is Lilavati, N. Lilavati. And before that, by considering that T.K. Rangarajan Malar. Specifically para 93 in 1997 3 SCC 260 hours.
লীলাবতী
No, no. Lilavati.
ওটা তো জানি লীলাবতী
কে রাঙ্গারাজন
Extraordinary.
Yes, come to paragraph 90
Yes.
of L. Chandrakumar.
Thereafter, Malar, kindly come to paragraph 93.
Please come to paragraph 90.
Yes.
Read it.
Yes. We may first address the issue of exclusion of the power of judicial review of the High Court. We have already held that in respect of the power of judicial review, the jurisdiction of the High Court under Article 226/227 cannot wholly be excluded. It has been contended before us that the tribunal should not be allowed to adjudicate upon matter where the virus of the legislation is questioned, that they should restrict themselves to handling the matter where constitutional issues are not raised. Cannot bring ourselves to agree to this proposition as that may result in splitting up proceedings and may cause avoidable delay. If such a view were to be adopted, it would be open for litigants to raise constitutional issues, many of which may be quite frivolous, to directly approach the High Court and thus subvert the jurisdiction of the tribunal. Moreover, even in the special branches of law, some areas do involve in the consideration of the constitutional question on a regular basis. For instance, in service law matters, a large majority of cases involve an interpretation of Article 14, 15, and 16 of the Constitution. To hear that the tribunal have no power to handle matter involving constitutional issues would not serve the purpose for which they were constituted. On the other hand, to hold that all such decision will be subject to the jurisdiction of the High Court under Article 226/227 of the Constitution before a division bench of the High Court, within whose territorial jurisdiction the tribunal comes.
Yes.
So that is in a normal situation. Madam, kindly, may I again read it and kindly read para 93. Because para 93 says one word very important. And if considering the L. Chandrakumar, T.K. Rangarajan, but specifically they deal in this matter in extraordinary situation, what would be the remedy?
Yes, read paragraph 91.
It has also been contended before us that even in the dealing with cases which are properly before the tribunal, the manner in which that justice is dispensed by them leaves much to be desired. Moreover, the remedy provided in the parent statute by way of an appeal, special leave under Article 136 of the Constitution, is too costly and inaccessible for it to be real and effective. Furthermore, the result of providing such a remedy is that the docket of the Supreme Court is crowded with the decision of tribunal that are the challenge on relatively trivial ground, and it is forced to perform the role of a first appellate court. We have already, so that means Supreme Court denied that role as a first appellate.
We have already emphasized.
We have already emphasized the necessity for the ensuring the High Court are able to exercise a judicial superintendence over the decision of the tribunal under Article 227 of the Constitution. In R.K. Jain case, after taking note of this fact, it was suggested that the possibility of an appeal from the tribunal on question of law to a division bench of a High Court, within whose territorial jurisdiction the tribunal be pursued. It appears that no follow-up action has been taken pursuant to the suggestion. Such a measure would have improved matter considered. Having regard to both the stated contention, we hold that all decisions of tribunal, whether created pursuant to Article 323A or Article 323B, the Constitution will be subject to the High Court of writ jurisdiction under Article 226 or 227 of the Constitution before a division bench, the High Court, within whose territorial jurisdiction the particular fall.
So therefore, all matters where there is a tribunal constituted,
Yes.
it will come before the division bench.
Yes, no doubt. It is a non-constitutional. But kindly come therefore paragraph 93, and after considering the L. Chandra Kumar, T.K. Rangarajan, my lord, what would be the extraordinary situation, and T.K. considering the T.K. Rangarajan very recently, Leelabati, my lord, I will place, my lord, one after another, my lord.
No, last judgment is 2020 volume 6 SCC.
Last
Roger
judgment-
Matthew.
Thereafter, my lord, very recent.
Now in Roger Matthew, come to the relevant part.
Last judgment is, as per my knowledge goes, my lord, in Leelabati. In Leelabati is the last judgment, my lord, 2025. This is although this is reportable, but
Come to paragraph 392 of Roger Matthew.
Roger Matthew is not my lord, actually with my lord, Roger Matthew is considered in MPLA, I believe.
Do you have Roger Matthew's judgment? Come back with Roger Matthew's judgment where it is stated that the litigants cannot wait for judicial impact assessment and action by the government which may or may not take place. Experience has shown the judgments of L. Chandrakumar, judgments right from L. Chandrakumar to Madras Bar Association 2010 have not been complied with by the union in letter and spirit. Citizens of this country cannot be denied justice, which is the first promise made in the preamble. Therefore, I am of the view that in whichever state, this is important. Therefore, I am of the Justice Chandrachud's judgment. Therefore, I am of it's a 5-judge bench judgment. Roger Matthew. Yes. No. Yes, 5-judge bench judgment. Where headed by Justice Ranjan Gogoi as his Chief Justice of India as his Lordship Denmark. Now it is therefore I am of the view that in whichever state, union territory, the bench of a particular tribunal is not established or functioning, the litigants of that state will have a right to invoke extraordinary jurisdiction on the jurisdictional high court under Article 226 of the Constitution for redressal of their grievances. They cannot be expected to go to far off distant places and spend huge amount of money much beyond their means to ventilate their grievances. The alternative remedy of approaching tribunal is an illusory remedy and not an efficacious alternative remedy. The self-imposed bar or restraint of an alternative efficacious remedy would not apply. Such litigants are entitled to file writ petitions under Article 226 of the Constitution of India before the jurisdictional high court. In L. Chandrakumar, it was clearly held that right of judicial review is a part of the basic structure of the Constitution, and this right must be interpreted in a manner that it is truly available to the litigants and should not be an illusory right. So, conjoint reading of paragraph 392 of Roger Matthew vis-a-vis paragraph 90, 91, 92, 93 of L. Chandrakumar. Yes, in L. Chandrakumar, when it has been directed and observed that right of judicial review is a part of basic structure of the Constitution. So therefore, the right of the High Court or the power of the High Court to have judicial review over the decision of the tribunal cannot be excluded. So therefore, the appropriate approach should be against the order of the tribunal to approach the division bench under Article 226 vis-a-vis 227 of the Constitution of India. Now, suppose in a case where there is no tribunal constituted in a particular state, then you can, taking a cue from Roger Matthew, paragraph 392, straight away you can approach the single bench. But when there is a tribunal constituted under 323, it's a case of Article 323A. In case of 323A, Article 323A, but members are not there, as a result of bench is not available, then the appropriate approach is to be to approach the division bench of this High Court. The writ court single bench cannot be transformed into a tribunal.
With deepest of respect, my lord, that is not the my lord, this latest position. Because of that, my lord, in T.K. Rangarajan case, my lord, 2003.
It's a 5-judgment judgment.
Yes, yes, but
there in paragraph 392, it has not been stated by the Honorable Supreme Court in Roger Matthew. In Roger Matthew, that it's a case of losing a forum, as a result whereof the litigant is required to approach the first forum. First forum. It's never said, nowhere. Rather, if you read conjointly paragraph 390, paragraph 90, 91, 92, 93, vis-a-vis paragraph 392, in a state where tribunal is constituted, but tribunal is not fixing the matter since members are not available, then appropriate remedy, according to my assessment, is to approach the Honorable Division.
But my lord, with deepest of respect, my lord, subject to correction, my lord, L. Chandra Kumar is all.
I have fixed one matter tomorrow. Let me consider.
Kind enough, my lord.
Let me consider this matter. Your matter I am fixing after a week.
As my lord, because of in coordinate, just my lord, one thing. In coordinate bench, learned advocate general is appearing in that matter, my lord. It will be kind enough.
No, I have also requested the advocate general to appear in this matter. In that matter, which I fixed, Mr. Shamim Ahmed is appearing to or Mr. Sudipto Dasgupta.
But then when fixed it, my lord, I will cite him.
No, I will not fix all the matters at it. I do not prefer this.
I may hand it over this judgment. It will be helpful for the beneficial for the.
Yes, that you can.
That will be. I can. That is my lord. T.K. Rangarajan 2000.
Just
with the relevant paragraph.
Yes, give me the citations.
That is my lord. T.K. Rangarajan 2003 6 SCC 581.
Yes. Give me the citation, please.
2003 6 SCC 581 para 10. Because in
581
para 10 relevant paragraph, because tribunal is functioning, then also the High Court, single bench taken up the matter in the extraordinary situation. When
the first judgment, then
yes, thereafter Leelavati, that is it is not citation is not yet reported, but it is reportable. Very recent judgment. Para 37. When because T.K. Rangarajan is considered. No, Leelavati. Sorry, may I?
You have given Tej Prakash.
Sorry, my lord. Sorry, my lord. Oh, sorry, my lord. That is for my merit. Sorry, extremely sorry. Leelavati, SLP number 27.
Just a minute.
Para 37.
Paragraph
37.
Just 37.
Yes, my lord. Now, my lord, Mogod Sugar.
Just a minute. Let me see paragraph 37. Do you have another copy?
Yes.
Of this Leelavati N and others, etc. Yes. Paragraph 37. Please place it.
Nevertheless, a retribution under Article 226 may still be maintainable, notwithstanding the existence of such an alternative remedy in exceptional circumstances, including the enforcement of fundamental rights granted under Part 3 of the Constitution, instances of ultra-virus or illegal exercise of power by a statutory authority, violation of the principle of natural justice, or where the violation of the parent legislation itself is under challenge.
But
So-
that aspect is that grounds are not available here.
Yes.
It's an exceptional circumstances, instances of ultra vires, part 3 of the,
Part 3, violation of
including
part 3.
enforcement of fundamental rights granted under part 3 of the Constitution, part 3 of the Constitution.
Yes.
Then instances of ultra vires or illegal exercise
That is
of
parent legislation.
power of statutory authority. Then violation of principle of natural justice, and where the violence of the parent legislation itself is under challenge.
That is always, but the violation of the.
So what
part
is the
3
special situation here?
Because of that, my lord, that is not functional. That is the special situation. Because of that, my lord, in pursuance of L. Chandra Kumar, 3-layered, my lord, is there. One is that as a court of first instance, SAT. Thereafter, as a way of judicial review, division bench. Thereafter, Supreme Court. So here, my lord, the SAT is not functional.
Here Roger Matthew was considered in Lilavati.
Considered.
5 judgment.
As far my knowledge goes, Roger Matthew is not considered.
It's a judgment of highest strength.
Yes, highest strength. Obviously, but the extraordinary situation. That's the my whole endeavor is
Yes,
that, Malad.
yes.
And another thing, Malad, I just cited more or 4 judgment, Malad. One is that Mogod Sugar, 2022, 16 SCC 428, para 20. Mogod Sugar, 2022, 16 SCC 428, para 20.
Yes, give me the judgment.
And the
Yes, paragraph
20.
Just a minute. Yes, just a minute.
7.3 specifically.
Paragraph
20.
20.
Yes, sir. 20.
Just a minute. Is a case of entertaining writ petition in the event there is availability of alternative. That will not apply here.
But the point is that,
That will not apply here. It's not a simple case of availability of alternative remedy. It is a case where under 1985 Act there is exclusion of the jurisdiction of the High Court. That jurisdiction was restored by virtue of L. Chandra Kumar. So it is not a case. It is settled principle that alternative availability of alternative remedy is not a blanket bar in entertaining the writ petition. It's a self-imposed restriction. Yes, but that will not apply here. It is a case where there is a constitution of a tribunal, and a tribunal is functioning, but tribunal members are not there, but tribunal is there. Whether matter is to be heard by the division bench or the single bench, in absence of a bench in the tribunal.
In
that is not a case, Mr.
That is extraordinary.
Mr. Shamim, that is not a case.
That's why, my lord, T.K. Rangarajan is the apt point, my lord. That, my lord,
well settled. It's a
Walpole
is it is tried that availability of alternative remedy is not a blanket bar. Same imposed restriction, and generally certain parameters are fixed by the Honorable Supreme Court, that where Alternative remedy is not a bar in entertaining a writ petition. That is not a case here.
Here case is that extraordinary situation. Extraordinary situation, why it's created?
Any other judgment?
Yes, another two, Whirlpool judgment, that is
The alternative remedy.
alternative.
All alternative remedy judgment, I am not interested.
Yes, yes. But here, my lord, the apt case is that T.K. Rangarajan and N. Lelavati. Because of that, my lord, but the extraordinary situation, the plenary power, because until and unless, my lord, it is not
That
taken
I
up by the single bench, my lord, then, my lord,
এই
and
এটা
lose the
একটা ইয়ে
forum.
দাও তো ব্যাক কভার দাও তো সাদা
If my lord one, I can assist my lord with you all, because I am also, my lord, as well as a learned advocate, because in that matter, my lord, both are, what would be the actual remedy, because it is all about, my lord, the legal argument, my lord. So that's why, my lord, if my lord wants, I can assist with you. I will try to ascertain, my lord, some judgment, my lord.
Leelavati says in a special circumstance.
Yes.
Some of the circumstances have been delineated there.
Yes.
But we ought not forget L. Chandra Kumar.
Yes.
Paragraph
L.
1991.
Chandra Kumar, rather we paint the High Court for the sake of judicial
In
review.
some union territory and some of the states, you will find that there is no constitution of tribunal.
Yes.
There, question of losing a forum will apply. But when there is a forum already, tribunal is constituted, but tribunal is not functioning due to absence of members. Now the straightway we used to move regularly.
That's when I am losing a forum. That's my extraordinary situation. Malad is created by the state. Malad, because two things. What my argument? One is that, Malad, I am deprived by the state act. State not created a tribunal. So, my logic is that, state deliberately, by not creating a tribunal, compel the petitioner to lose a forum. That's my argument, because there is, L. Chandra Kumar says, in normal circumstances, 323A, any tribunal is constituted, then High Court is empowered to review that Court of First Instance judgment.
It's a judicial review power.
Yes.
High Court exercise.
Now, the question is that is not about judicial review. L. Chandra Kumar is all about High Court judicial review. This is not about judicial review. Now, question is that, my lord, whether extraordinary situation is created. If this type of extraordinary situation created, what would be the remedy? Because this is.
Well, I'm considering this.
Just my 2026 SCC1
matter is heard in presence of the learned advocates representing the parties. Stop. Question arises for consideration in absence of members in West Bengal Administrative Tribunal, whether writ petition is maintainable before the single bench of High Court at Calcutta, before the single bench of the High Court, or before the division bench, or before the honorable division bench. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration. On. January 14th, 2026.
Next matter is also
14th January, simple.
Yes,
14th January.
In the meanwhile, if I got some other judgment, my lord, I will, my lord, for as being an officer of the court, I will assist.
Yes, call the list.
Item number 7.
I beg to appear on behalf of this. No, 7 টা তো হয়ে গেল।
Yes. Yes, item number 7. 6 and 7 না 5 6 and 7 সেম অ্যাডজেন্ট করে দেওয়া হয়েছে 7 প্লিজ অ্যাডজেন্ট
No, I have done the 8.
একই ম্যাটার। Item number 8.
I beg to appear on behalf of the state here.
My lord, I am for the item number 8 and 9. I pray for not today, my lord.
who is for the petitioner?
My lord, I am for the petitioner.
You are for the petitioner? You have said 8 and 9.
Yes, my lord.
Why not today?
Because my lord, my senior, my learned senior
Nine
is out of
actually.
station, my lord.
Who is your learned senior?
Aisha Nasi,
Where is she has gone?
out of station, my lord.
Where she has gone? Court has reopened. Why she is out of station?
My lord, please.
Matter was taken up on the last occasion also.
My lord,
Nobody appeared. This cannot continue.
for today only, my lord, kindly give me not today, my lord.
দেখি কি চাইছে? What is the matter about?
The matter is that, my lord, his allegation is that his salary has been suddenly stopped. He is seeking for the salary. The fact is, my lord, otherwise. If your lordship kindly take trouble to see the chronological event of the
Just
yes. Please.
পোস্টও নেই, সাবস্টেশনও নেই। আমাদের কোনো অফিসিয়াল কোনো নিয়োগ হয়নি।
At the time of call, accommodation is prayed for on behalf of the petitioner. Stop. However, state respondents are represented by land advocate. List the matter under the heading motion in the monthly combined list of February 2026.
Only one thing may I be permitted to mention, my lord. This matter possibly has been done in a different way altogether. A sharp practice has been done. The person concerned who is claiming to be a employee of the government of West Bengal and he is not.
Let her come. Yes, please call the next matter.
Next matter, I appear.
Item number 9.
Same, minute.
Yes, 9, item number 9.
চলে গেল।
He asked for the 8 and 9 together.
Same order. Monthly list of February.
Item number 10.
My lord, I am for the.
Who is for the other side?
Only my lord state is that.
Nobody is appearing today.
My lord, in earlier occasion, 2 days, my lord, one appears 1 day.
Who is appearing for the state?
All state.
Who is appearing for the state?
One planet advocate appeared. Like 2 days they.
No, this is the first time this matter is taken up.
In earlier occasion, your lordship take up the matter and take time. 1 day. This is second time of litigation. Earlier occasion, your lordship.
Sir, notice about the learned advocate representing the state. Issue. Yes, place your case.
The petitioner joined as a my lord honorary worker as a civil caste category, my lord, in the year 3rd December 1985 as a contractual employee. Then my lord, her service has been confirmed, my lord, on 7/8/1995 as a honorary worker, and my lord, since 1995 as a my lord.
What you are praying for? Regularization?
No, my lord.
Then?
Earlier occasion, the CDPO, that is respondent number 7, my lord, declared the petitioner as a my lord retired employee, and by deleting the date of birth in his service book, they my lord, the CDPO issued one notice and declared him as a retired employee. I filed a writ application challenging that notice. Your lordship directed dispose of the matter with a direction that the petitioner will work as a permanent employee till the date of superannuation. My lord, that petitioner joined on that post, and my lord, from the month of September, the CDPO, my lord, did not disburse the salary, and the petitioner did not get the salary. Even my lord, the petitioner did not get the salary.
Same petitioner has approached this court.
Yes, my lord, your lordship's order in earlier occasion, page 51.
Against this, no appeal was preferred.
Nothing.
So now your contention, you are not receiving salary, remuneration.
No, from September, no salary has been given. As
September, I passed order on 7th November.
7th November, my lord, setting aside the notice issued by the CDPO, that
Yes.
is page 33. Page 33, the issued notice has been set aside by your lordship.
Yes.
And this notice has been issued in the month of September. And from that time, they did not disburse the salary.
Now you are not receiving remuneration from November 2025.
September.
September 2025.
They are not allowing me to running my center. That is without my lord delivering me any food grades, nothing.
Yes.
My lord, page 70, my
Yes.
representation.
Why remuneration is not being paid?
He has already returned.
This has already been decided by this court.
No, no.
And that has been negated.
Lordship grant leave to make an inquiry and take necessary steps. Lordship, kindly see my lord's order, page 52. 52, 11 portion, my lord. Page 13. Lordship grant leave.
Paragraph 13.
Paragraph, sorry.
Respondent number 7 shall be at leave in the event said respondent has doubt relating to the date of birth of the petitioner to initiate appropriate proceeding against
Yes,
the
that
petitioner.
proceeding has been initiated and order that
Petitioner was granted opportunity to make deliberation before the authority. Where is that?
Lordship, kindly see.
Then I have to make an appropriate order against this CDPO. Yes, where is that?
Lordship, kindly see.
Show me that any opportunity of hearing was granted to the petitioner.
One minute, my lord. Yes. Page 7 onwards.
You show me that any notice has been given to the
Notice
petitioner.
has been given. 7 onwards, Lordship, kindly see. And page 6 is the date of birth, 24th August 1960, who has claimed at 2665, that is not.
Now first tell me that where is the payment of remuneration from September to December?
So September to December is not because August. Lordship, kindly.
No. Previous order of retirement was was set aside by this court.
Yes,
So
yes,
where is the
sir,
payment?
lordship granted leave.
Where is the, yes, leave was granted, but where is the payment? Till the
Payment
date of,
August, we have
till the
retired-
decision
retired-
was taken,
it
till
has
decision
got-
was taken, petitioner is entitled to get a remuneration. Where is that?
No. He has superannuated pursuant to my lord's order on say, August 30th. 30th August.
That decision was negated by.
No. Lordship kindly, thereafter Lordship granted leave to the respondent number 7.
For initiating appropriate proceedings.
Yes, that
So
is
that when these proceedings came to an end.
came to an end, Lordship kindly see, every matter, every order, Lordship kindly see, Urmila da.
When these proceedings came to an end.
That is it on, we got certificate from the school.
When these proceedings in terms of the order dated 7 November came to an end.
I think regarding hearing is concerned, I am not aware about it.
Then petitioner is entitled to get remuneration till the date of end of proceedings. Today, Mr. Additional Government Pleader, today a disciplinary proceeding is initiated against a person.
This is not.
Please hear this court. A disciplinary proceeding is initiated against a person.
Right.
That proceeding is, and by passing a termination order, a person has been ousted from service.
Right.
That is challenged before this court. Now that order of punishment of removal from service is set aside by this court, granting liberty to the disciplinary authority to initiate appropriate proceedings if situation so arises.
Right.
Does it obliterate the right of that person against whom disciplinary proceeding is initiated? Please hear. To initiate disciplinary proceedings to get salary till the end of the de novo proceeding. You are an officer of this court.
When my lord coming, my lord, when my lord will come. Practically, he is a casual, contractual.
Whatever he may be,
I am not.
against this order you have
not sending it down.
against this order you have not, against this order you have not preferred any appeal.
No, I don't your lordship.
Yes,
order.
in that event,
Lordship
tell
order.
me what was the date when this proceeding, de novo proceedings came to an end.
That I have to take instruction for.
So in that event, at least till the date of ending de novo proceedings, petitioner is entitled to get remuneration. Why it has not been paid?
No, unless.
It's a contempt on the face of it. Showing thumb to the order of this court. Your CDPO. Yes. What? No. What? No. It's a contempt showing thumb to the this court. Yes, I am taking. Because of this conduct.
Then I leave it to your lordship. Let it be well. Lord.
Enough is enough. I have passed a detailed order setting aside the order of retirement. Then you may initiate proceedings. Does it mean that you will misuse this liberty?
Pursuant to my lord.
Then henceforth I will not give such liberty to anybody.
That is.
Yes. And till date you show me when these proceedings came to an end.
That has to be.
Has to be. Then first pay the salary. First pay the remuneration to the petitioner.
I have to take instruction for that. Whether the proceeding is initiated, how it is completed, that has to be.
Why you have not taken any instructions till date?
That has to be my last before.
We will take instruction tomorrow.
Tomorrow, my lord,
take instruction with CDPO. Goshaba. We will next Tuesday. Come back.
Why? I have to take instruction, my lord. Please. Don't take amiss, my lord.
Yes, I am taking. Without applying your mind, you are just making a submission on being instructed by your client.
Tell my CDPO. I have to tell that the court.
He has just misused my leave granted in my previous order dated 7 November 2025. I am taking Mr. Additional Government Pleader. Today, a person is maybe removed from service. If that removal goes, that is in. I am giving an analogy, an example. If that removal goes, if de novo proceeding is initiated in terms of the leave granted by this court, why remuneration is not paid?
That has to. I have to take instruction, my lord, whether initiated proceeding.
देखिए এটা দাও তো পিটিশনটা have you gone through the order dated 7 November 2025 please read this order please place it page 51
Mal. Working as ombudsman worker contractual basis she was working as a interpolation that is in support of this.
in view of aforesaid consideration impugn notice
My lord.
dated 11th September 2025 is set aside.
Mal.
Now whereby date was fixed for retirement of the petitioner on in August 2025. In August 2025. Now it is considered by this court previously, paragraph 9, transfer certificate previously submitted by the petitioners, Aadhaar card, voter identity card, PAN card, and particulars of petitioners uploaded in the service portal were not taken into consideration. In order to arrive at a conclusion relating to date of birth of the petitioner by the respondent number 7, that is the CDPO. You show me that in these proceedings, this Aadhaar card, voter identity card, and PAN card and particulars of the petitioner was considered. Show me. Otherwise, I will injunct it. Show me.
Finally, page 7.
Page 7.
Page 7 of the instruction.
Yes.
Compliance of minors. With reference to Chancellor Lordship Court. To attest to Urbilada's petition, directed to report to the office of the undersigned on Atho for receiving necessary instruction in connection with your functioning as Honorable in compliance with the order passed by your Lordship. You are informed that as per aforesaid order, testimony number 7, that is undersigned shall be deemed to initiate proper proceeding against you in order to ascertain whether the actual POV is different from the POV that indicated the document submitted by you.
Leave to initiate appropriate proceedings. Has to be made to ascertain your actual date of birth is different from date of birth as indicated in the documents. Yes, yes.
Okay. Next date, Lordship.
That is on 15 December.
15th.
Yes.
Then, madam, next page, page 18. That is part to that, 25th August 2025. There is a letter addressed to my petitioner.
Prior to that, which page of your instruction?
Page 8.
8.
Page
8. Yes.
It is my letter.
Yes.
You know that. Sorry. That has to be part. That to that, आपने जाना चाहिए आपना जो school transfer certificate होना
No, that is the transfer. Yes,
record of
you are absolutely correct that this notice was set aside by this court.
Yes.
How this can be revived?
No, I cannot revive. I'm just going to indicate. Well, I got
This was set aside by this court. How your CDPO can revive it?
No. Revive due to my lord transfer certificate. They dispute.
If you are not satisfied with my order, you could have preferred an appeal. But in your own CDPO, how can CDPO?
I bow down your lordship order.
Yes.
Lordship kindly see my page 6. This is the school certificate. 5th December 2025, after my lordship.
When this was issued?
School certificate.
When it was issued?
5th December.
After my order was passed.
Yes. My lord was passed.
We know what has happened very well. We know when this was issued. Whether the copy was sent to, whether this copy of this transfer certificate was sent to the petitioner. Show me. Yes. Show me.
This is the next letter, page 7.
Yes.
Receiving necessary instruction.
Show me that this transfer order was sent to the petitioner.
That I have to take instruction.
No, show me.
No, I right now I cannot.
Sorry, show me that this newly issued transfer certificate was sent to the petitioner before taking decision. Otherwise, I will direct the subdivisional officer to stop salary of CDPO.
No.
Yes.
Lordship,
Yes.
The next date, my lord.
No, not at all. You show me that it was sent to the petitioner.
No, I do not know, madam.
Yes.
I cannot get it, but I do.
Much water has flown to river Ganges so far this matter is concerned, Mr. Additional Advocate Government Pleader.
I do not know, madam.
Show me
Which water
that this was sent to the petitioner and petitioner was shown that this is your transfer order by the school authority, on which I am CDPO relied upon.
My lord, I cannot say, my lord, unfairness. I have not practiced that type of practice.
Yes.
Your lordship knows. That is why, my lord, I have to take instruction, proper instruction.
Where is that previous transfer order? Interpolated and overwriting?
Yes, that is page 46. Page 46.
See this transfer order based on which your CDPO took decision. At the bottom left hand side, 3rd December 1985 was changed 11 September 2020. Then her date of birth as recorded in the admission register was 24th August 1965 was changed to 1960 by overwriting, handwriting. Who did this?
Who was this? Who did this? I
Yes,
don't know. Who
that-
did this?
Petitioner will not do this in order to shorten his tenure of service. That was the consideration before this court. Petitioner will not dig his own grave by raising his by enhancing his her age.
Lordship, in that case, Lordship, kindly direct my fairness, Lordship, kindly direct the CID. CID West Bengal to
Nothing is required. Court knows how
Handwriting.
to tackle this situation.
Handwriting. No.
What I will do, I know.
I am submitting only.
What I will do, I know. But what about the conduct of CDPO? First, I will direct the SDF subdivisional officer to stop salary of CDPO because of his conduct.
I have to take inside some days required.
Yes.
Thereafter, Lordship, kindly pass necessary order.
In the meantime, this order shall remain state. Where is the order? Fresh order?
At page 33. Fresh order one that was not intimated. Nothing has been intimated.
Nothing.
Nothing has been intimated.
That is.
My lord, for that
Whether-
reason
Whether it is
See the position.
I
I have directed to initiate appropriate proceedings and no order has been communicated to the petitioner.
that has to be. I can give. My lord,
Why remuneration has not been paid? It's a contempt on the face of it.
I can satisfy your Lordship. My lord, Lordship, kindly give me 3 days or 7 days. I can come back. Come back with all papers. I am
the officer of this court.
Yes,
Very unfortunate that you are trying to defend
back, my lord.
defend
I am
the
not-
officer,
I am not unfairly the job. I am supporting this type of practice.
but it appears so.
I am not supporting this type of practice.
See that no order has been passed.
I fairly submit and on that particular date, the Lordship kindly set aside this and continue
Yes,
this
sure.
service on that particular date. Lordship, fix the date.
Matter is heard at length in presence of the learned advocates representing the petitioner and state respondents. It is submitted by the learned advocate representing the petitioner. Next numbering দিয়ে করবে paragraph. Next paragraph. It is submitted by the learned advocate representing the petitioner, relying upon the order dated 7th November 2025 passed by this court on the writ petition being WPA 24730 of 2025 within bracket Urmila Das versus the state of West Bengal and others close bracket, that কি বলছিলাম সেন্টেন্সটা so and so did petition that that notice dated 11th September 2025, previous notice, retirement notice.
That is page 33.
Right.
September 2020.
September, that by notice dated 11th September 2025. Date of superannuation of the petitioner as Anganwadi worker, under Gosaba child, under Child Development Project Officer Gosaba, South 24 Parganas.
Para 2, page 4.
Being respondent number 7 was set aside. It is also contended that relying upon one transfer certificate dated 11 September 2000. Date of retirement of the petitioner was scheduled on, was wrongly scheduled on 31st August 2025. Stop. Petitioner in order to substantiate her case relied upon transfer certificate dated 3rd December 1985. Where is the transfer certificate?
That is first
Page.
Page 20 onwards. Page 20 is my Aadhaar card. Page 21 is my voter card. Page 22 my income tax certificate, and page 23 transfer certificate, and another my 30 total. Page 25.
This is 6 March 2020. This 3rd December 1985 transfer certificate.
And that's, that certificate, my lord, was not with me, my lord. Subsequently, after my lord dispute has been arise, page 23 school my lord gave me a transfer certificate, another transfer certificate. And in my lord appointment letter also, my date of birth was also there.
হ্যাঁ কি বলছিলাম? Transfer certificate dated 6th March, 6th March 2023, as well as Aadhaar card, voter's identity card, and PAN card.
Service portal, page 25.
Stop. Taking a stop. On finding, next paragraph, on finding the transfer certificate dated 11 September 2020, 11 September 2000, containing overwriting and interpolations. Especially date of birth, especially year of date of birth of the petitioner was changed from 24th August 1965 to 24th August 1960 by overwriting. Court passed order dated 7th November 2025 in the writ petition being WPA 24730 of 2025, thereby notice, thereby superannuation notice dated 11 September 2025 was set aside. Stop. Petitioner was directed to function as Anganwadi worker till her date of superannuation based on the documents submitted by the petitioner previously. Stop. However, respondent number 7 was granted leave to initiate appropriate proceedings against the petitioner if said respondent number 7 has doubt relating to date of birth of the petitioner, comma, to find out whether petitioner's date of birth is different from the date of birth as indicated in the document submitted by the petitioner. Next paragraph. Mr. Debray, learned additional government pleader, by submitting certain documents, has stated that on 15th December 2025, a notice was issued to the petitioner directing her to appear before the respondent number 7 on 19 December 2025. Stop. Reliance is also placed on Page 6. A certificate dated 5th December 2025 in order to contain that date of birth of the petitioner was 24th August 1960. Next paragraph. It is true that Vide order dated 7th November 2025. This court permitted the respondent number 7 in case of doubt to initiate appropriate proceeding for determining correct date of birth of the petitioner. Stop. But from the submissions made on behalf of the state respondents, it appears till date no final decision has been taken relating to determination of date of birth of the petitioner. Stop. Moreover, prima facie it appears that order was passed by this court in the writ petition being WPA 24730 of 2025 on 7th November 2025. Setting aside termination notice dated 11th September 2025. And the certificate issued by the school authority, which is being which according to Mr. Devray, learned additional government pleader, based on which steps are being taken by the respondent 7 is dated 5th December 2025. Stop. Therefore, it transpires after order was passed on 7th November 2025 by this court. Respondent number 7 made an effort to obtain certificate from the concerned school on 5th December 2025. Stop. However, nothing is shown from where it can be demonstrated that respondent number 7 made an endeavor while initiating proceeding against the petitioner to determine her date of birth, relied upon certificate produced by the petitioner at the time of her appointment in 1995.
My lord, that is past 1985. My lord, if your lordship can see for a moment.
Produce certificate of the school authority, of the same school authority, at the time of her appointment, which is dated 6th March 2023. Sentence bolo. সেন্টেন্সটা তো হলো না। Relying upon relying upon the certificate dated 6th March 2023, as well as PAN card, Aadhaar card, and voter's identity card. Moreover, no final order is passed till date relating to date of superannuation of the petition. Stop. Next paragraph. It is alleged on it is contended on behalf of the petitioner. Next paragraph. It is contended on behalf of the petitioner that neither she is being permitted to function as Anganwadi worker, nor her remuneration is being paid from September 2025. Stop. Next paragraph. In view of the situation as it appears post 7th November 2025, post order dated 7th November 2025, passed on the writ petition being WPA 24730 of 2025. Concerned respondent authorities, including respondent number 7, is directed to permit the petitioner to function as Anganwadi worker and pay her remuneration from September 2025 by 7 days from date. Stop. Next paragraph. List the matter for further consideration under the same heading on 9th February or on 3rd February 2026 in order to enable Mr. Devrai, learned additional government pleader, to obtain further instructions. But pay salary and permit her to function. Report kept on. Yes, the documents filed on behalf of the state respondents are taken on.
My lord, one line, my lord, permitted the petitioner to work, my lord.
That I have directed. At the much obliged.
Item number 11.
I'm for the respondent. My অমিত আগের দিনও আসবে না, কিছু হয়েছে কিছু জানো? কবে আসবে? একবার ইয়েকে নরেনকে ডাকো তো, নরেনকে ডাকো এখন। Yes.
Petitioner applied for constable GD in Central Armed Police Force. Subsequently, physical test was conducted, and all the petitioners are passing the physical test. Subsequently, a medical test was examined thereafter. In the medical examination, kindly come page number.
Constable GD.
Constable
GD in Central Armed Police Forces.
In the medical examination, petitioners were.
Where is the review medical examination report? Which page?
Page number 21. Review for medical unfit. 2 centimeter oblique marks.
Yes, what is the ground?
2 centimeter oblique.
Unfit on account of. Please come to page 21 against clause 3B. Read it. What is the ground? So medical term you have to demonstrate before this court.
2 centimeter oblique marks.
No, multiple parallel then.
Multiple parallel cut marks on the
Left forearm. More than 1 dozen.
Why there are multiple cut marks, more than 1 dozen on left forearm? Yes.
But that is the reason of petitioners unfit, my lord. There are several petitioners, my lord.
Including suicidal intent. It is written.
My lord, it is here, my lord, showing a cut marks that it is a suicidal.
Yes, yes. Cut marks on left forearm, more than 1 dozen, indicating suicidal intent. So how petitioner will be considered as a fit candidate? Do you have cut marks on your forearm? Then why petitioner has? It's not a disease. So therefore, why, or any congenital defect, nothing. That court can understand, but why multiple cut marks? It's not a case of removal of tattoo by laser surgery. Then why cut marks?
There were several petitioners, my lord. That is petitioner number, rejection ground for petitioner number 1, my lord. And now, my lord, can you come?
We will file a report.
23.
File a report.
My lord, there are 4 petitions, my lord.
4?
4 petitioners. 4.
One writ petition.
That is what.
Permissible.
Only one.
And no, maybe, but the reasons are
different causes,
different.
different causes,
How court
man.
can consider it separate in one writ petition?
Under one.
By the same reason, 4 petitioners have been
No.
different reasons. Then
My lord, P1 and P2, my petitioner number 1 and petitioner 2 are of same nature. P3, petitioner 3 is of tragedy, and petitioner number 4 is of hyperpigmentation. All are different causes, my lord.
so writ petition will be entertained in respect of petitioner number 1. In respect of other petitioners, it will be dismissed, but you can file a fresh writ petition challenging identical issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. It appears that espousing different causes of action, 4 writ petitions have joined together in this writ petition. So, though all the writ petitioners were declared unfit, though all the writ petitioners were found not eligible to be appointed for the post of constable within bracket GD under Central Armed Police Forces within bracket CAPFS close bracket. But reasons for negating candidature of the petitioners are different. Stop. Therefore, petitioners ought not to have joined in one writ petition, espousing different causes of action. Espousing different causes of action. Next paragraph. Hence, writ petition stands dismissed in respect of petitioner numbers 2, 3, and 4, and the present writ petition shall be entertained in respect of petitioner number 1. Within bracket, petition number 1 and within bracket, hereinafter referred to as petitioner. Close bracket. Hereinafter referred to as petitioner, quote unquote. Next paragraph. However, this order shall not preclude petitioner numbers 2 to 4 to take steps in accordance with law on the self-same cause of action if they are aggrieved by the acts and actions of the respondent authorities. Next paragraph. Petitioner number 1 was found unfit in review medical examination held on 24th November 2025 on certain grounds on the ground delineated therein. Next paragraph. Concerned respondent authority is directed to file a report in the form of affidavit disclosing as to why petitioner was
Rejected.
found unfit in review medical unfit in review medical examination. Stop. Next paragraph. Let such report be filed by 3 weeks from date. Stop. List the matter under the same heading for further consideration on 3rd February 2026.
Much obliged.
Why?
Requirement notification is
not required. I have not granted you any leave.
Item number 12 is also a similar matter. If you
Come back.
The second half, your lordship will